Companies Act Section 33, Issue of Application Forms for Securities. Section 33 of the Companies Act establishes crucial guidelines regarding the issuance of application forms for the purchase of securities by companies. This section aims to ensure that potential investors are adequately informed about the securities being offered, thus promoting transparency and informed decision-making in the investment process. The following is an in-depth exploration of the key provisions and requirements laid out in this section. 1. Requirement for application forms. General Rule. Abridged prospectus requirement. A fundamental rule established under this section stipulates that application forms for the purchase of a company's securities cannot be issued in isolation. Specifically, any application form provided must be accompanied by an abridged prospectus. The abridged prospectus serves as a condensed version of the full prospectus and contains vital information about the securities being offered, as well as details regarding the company itself. This requirement is designed to ensure that potential investors have access to essential information that will aid them in making informed investment decisions before submitting their applications for securities. Purpose of the abridged prospectus. The inclusion of an abridged prospectus with application forms is intended to provide a summary of key details such as the nature and rights attached to the securities being offered, the financial health of the company and relevant performance metrics, the risks associated with the investment and any factors that could impact the value of the securities, information about the management and corporate governance of the company. Exceptions. While the requirement to include an abridged prospectus is generally mandatory, there are specific exceptions where this rule does not apply. A. Underwriting agreements. In instances where the application form is issued as part of a genuine invitation to a person to enter into an underwriting agreement regarding the securities, the requirement for an abridged prospectus does not apply. An underwriting agreement is a commitment made by underwriters to purchase the securities if the public does not fully subscribe to them. This exception recognizes the unique nature of underwriting arrangements, where potential investors are usually well-informed parties who understand the implications of their commitments. B. Non-public offerings. The requirement also does not extend to application forms related to securities that are not offered to the public. This includes situations such as private placements or other restricted offerings where there is no need for the widespread dissemination of information typically associated with public offerings. In these cases, the application forms may be issued without the accompanying abridged prospectus, as the audience is limited to specific, identified individuals or entities. 2. Provision of prospectus. Right to access. Accessibility of the prospectus. The section further emphasizes the importance of transparency and investor rights by stating that any person who requests a copy of the full prospectus must be provided with one. This request can be made at any time before the closing of the subscription list and the associated offer. By ensuring that interested parties have access to comprehensive information about the securities being offered, the Companies Act aims to empower investors to make well-informed decisions. Implications of the right to access. This right not only promotes a culture of openness but also aligns with best practices in corporate governance. By allowing potential investors to review the full prospectus, companies can build trust and foster positive relationships with their stakeholders. This measure also helps mitigate the risk of misinformation and misunderstandings regarding the investment opportunity being presented. 3. Penalties for non-compliance. Fines for violations. Regulatory compliance and penalties. Section 33 underscores the significance of adhering to its provisions by imposing penalties for non-compliance. Specifically, if a company fails to provide an abridged prospectus alongside its application forms as required, it will be subject to a penalty of 50,000 rupees for each instance of such non-compliance. This penalty serves multiple purposes. Deterrent effect. The financial repercussions are intended to deter companies from neglecting their obligations, thereby reinforcing the importance of compliance with regulatory requirements. Investor protection. By enforcing penalties, the Act aims to protect investors from potential losses that could arise from being inadequately informed about the investment opportunities available to them. Promotion of transparency. The imposition of fines reinforces the overarching goal of maintaining transparency in the capital markets, ensuring that companies prioritize the dissemination of accurate and comprehensive information to potential investors.